come into the UK, because of course we all know that even though uh, free movement was allowed whilst the UK was part of the EU, because we are no longer part of the EU. So even if you're a family member of an EU national, you now require a visa to come into the UK. If you're an EA national, you wouldn't require a visa because you're an EA national, and therefore you can come with your passport. But from the 1st of October, you would not be able to come with just your ID. And if, of course, you already live in the UK and you have a biometric card which has leave to remain, or which has the 5 years residence card, or you basically have permanent residence and you've applied to the pre-settled status, you've applied for the pre-settled status or applied for the settled status, then of course you can use that when you're entering the UK. So you don't necessarily need to have just your passport. You would need the passport and the card to travel when coming in and out of the UK. So yes, just a bit of update in terms of our immigration rules and what the Home Office policy is as of now.
Mm, mm. Wonderful. Right. So, Laura Eunice, applying for British citizenship outside the UK. Sometimes people feel it's only but what I wanted to know first of all is it easier applying within than applying outside of the UK?
Well, it depends. So if yes, so if for instance, your parents were not British or were not settled at the time the child was born,
Yeah.
then of course you would think that it is appropriate that when the child joins you, then you would be able to register them as British. Whereas
Mm,
those who had parents who were British or settled before they were born, because of course the law allows under Section 2 of the British Nationality Act for them to even apply for a British passport, because they are British automatically,
mm,
they
mm,
would then go on to apply for British citizenship for that child because their parent was settled or their parent was British at the time that they were born. So, of course, if that is the case, it could be somebody who is even an adult and they
mm.
want to apply for their adult child to have British
Okay.
citizenship. So, once they have gone through that process, and they would need a lot of evidence to verify that indeed you
Mm,
are the child's parent, and
mm, exactly.
that child of course is entitled to
Mm,
it.
mm,
So it can
mm,
take quite a while. It's not as simple as can be. So
mm.
maybe
Right.
the question should have been, how different is it for somebody who was born in the
Was
UK to somebody who is born outside of the UK? Because those that are
mm,
born outside the UK, it certainly takes quite a longer period of time for them to make a decision than those who were born in the UK.
okay.
Yeah.
Right. So, Laura Eunice, who is a minor or child for the purposes of the British Nationality Act 1981?
So when you look closely at our British Nationality Act, so I just mentioned that even if a child was now an adult, based on our Section 2 of the British Nationality Act, you would still be able to apply for British passport because that child will be British automatically. But when it comes to those, for instance, who, let's say their parents went for them whilst they had just leave to remain, they didn't have settlement or they didn't have British citizenship at the
Yeah.
time, and they went for their children because, of course, the rules also allow for that. A child who basically has a parent living here with just leave to remain can also bring their child to come and join them. Or even now that we have our EA nationals under the immigration rules, somebody who has pre-settled status or limited leave to remain under the EU settlement scheme can also bring their child to join them. And previously, you have those who would bring their children to join them, and they'll be granted 5 years residence card. So you have all these different categories of people who would be able to bring their child to join them, not necessarily having settlement or indefinite leave to remain. And so, of course, if you were in that category of people and you went for your child and now your child lives with you and you are thinking, now we have indefinite leave to remain, what can I do to apply for citizenship for my child? Then, obviously, the obvious route will be looking under Section 3 or even Section 4 of our British Nationality Act. So, a minor as within the act would be somebody who was under the age of 20, I mean, under the age of 18. So
18.
if that person, yes, is wanting to register their child, then they would be looking to register that child um, who is under the age of 18. Of course, if by the time you are making the application, the child turns 18, then it'll obviously mean that the child will have to apply as an adult in their own right rather than as a child. And so that is the only difference where if somebody who had settlement before the child was born would definitely apply for the passport straight away, whereas in a case where there wasn't settlement or British citizenship, that person will have to register their child as British before they can apply for the passport. So yes, for the purposes of the act, the child was somebody who is under the age of 18.
18. Okay. All
Yeah.
right. Does the British Nationality Act 1981 allow those children whose parents are no longer together the opportunity to still register as a British without the consent of the parents?
So yes and no. The reason why I say yes is because there are certain sections within the act where, for instance, the child's parents may no longer be together and they would have to look at the circumstances in which the child is registering as British. And if it's the case where, for instance, the caseworker has a discretion to grant British citizenship, as in Section 131 of our British Nationality Act, then they may not necessarily need both parents to consent to the registration. If, for instance, the other parents' whereabouts are unknown, or the other parent doesn't want to give their consent whatsoever, and so of course the caseworker or the Home Secretary has the right to use their discretion to basically say, okay, since uh, the other parent is not willing to give consent,
Yeah.
and there is nothing like a court order, or there isn't anything that prevents the other parent from registering that child, then they will go ahead and issue that child with a certificate of registration. But you have under Section 34, for example, where it is a statutory requirement that the parents have to both give consent before the child can be registered. And so
Oh,
if it happens that this child is being registered and the consent of both parents is a statutory requirement, then it means that unfortunately, if both parents do not consent to the child being registered, then unfortunately, the child cannot be registered. So it's very rare in those cases because it's not very often that you will have um, a child registering under that section. So in those sections or in those cases, it's very rare. And most of the time, um, our children who are born in Ghana or born in Nigeria or born in any part of the world who then come to the UK are
mm,
able to then register if the parents now has settlement and they also have settlement and they want to register whilst under the age of 18. So most of these applications will be done under Section 3(1), for instance, where the Home Secretary has a discretion to basically grant that child British citizenship. Yeah.
Okay, all right. Ladies and gentlemen, if you've just joined us, this is Heritage TV, the BWF Legal Hour show with me, your host, Vicky Newton. If you would like to contribute or join in the discussion, you can do so on all our social media handles, Facebook, YouTube, Periscope, and we'll be very glad to hear from you. If you rather prefer to call me live on the show, the number to call is 0744 8619 711. The number again is 0744 8619 711. Today's topic is applying for British citizenship outside the UK. Please share to all your contacts. I believe that someone, this discussion will benefit someone in your contact group. So please share. Laura Eunice,
Hello.
what are some of the circumstances in which a child born outside the UK can be registered as British?
Okay, so we have quite a number of circumstances in which a child can be registered. So, as I mentioned before, um, of course, if, for instance, a parent has leave to remain and they go for the child and they obviously are granted leave to remain in line with their parents, and then eventually, of course, the parent has been granted indefinite leave to remain, so the child is also granted indefinite leave to remain, and they want to register this child as British, they can go on to register this child as British under Section 3(1) of our British Nationality Act. So you have circumstances such as where, for instance, both parents are British and the parents themselves obviously were British because of their parents. And so, if, for instance, I was British and then my parents were also British and their parents were also British, and it's basically along the line of um, as being British by descent, if I were to live outside the UK for a while and then had a child outside of the UK, I wanted to register this child as British. Usually they'll be wondering if, for instance, I and the child's father were together, and if we were together, then of course they would want us to register this child as
Mm,
British, and you could do that, and they want to know if this child, of course, is a minor, so it's not just you're not just saying that it's your child, but the child, of course, is under the age of 18, and you are also saying that, of course, since you came to the UK, so you've come back to the UK, this child has lived here for at least a period of 3 years. And of course, you think that this child is entitled to British citizenship just as you are British. And so, of course, once they are looking at it in that sense, they would then register the child with both parents giving their consent, because this is one of the cases where they need both parents to give their consent. And therefore, once consent has been given by the parents, then they can go on and have the child registered as British, for instance. And then you also have a situation where, for instance, I'm British, my parents are British, but my parents did not become British through their parents. So my parents, for instance, naturalized. So because they naturalized as British and I
okay.
am now British, my child is also um, British because of the fact that, of course, I've had my child outside of the UK and I've now had my child come and live with me in the UK,
Mm.
and
Okay.
my child has been living with me for the past 3 years. And so, of course, if I'm able to show that um, I myself am British because my parents were British, but my parents were not British by descent, so they did not have their parents pass on their British citizenship to them, so they naturalized and they have now become British. And my child
Okay.
has been living with me for at least 3 years. That is also another route through which the child can also register as British. And then you have other situations where, for instance, the child's parents may be in the army, and so they're outside of the UK when the child is born, or they are working within um, a common, or should I say, a government service within any other country which is not the UK, or for instance, they were born out in an overseas territory. So, for instance, Hong Kong used to be a UK overseas territory, and so because they were born in Hong Kong at the time, it used to be one of the territories of the UK. They are also likely to be registered as British. And people who, for instance, were working within an EU institution for the UK, they may also have children outside of the UK and should be able to register their child as British. And so you
Okay.
have all these different categories of people who could also register their child
Right.
as British if they were born outside of
Okay.
the
Well,
UK.
Eunice, we've got a caller on the line. Let me put her through. Hello, caller. What's your name and where are you calling from?
My name is Josephine. I'm calling from Northampton.
Wow. Okay. Welcome to the program. Lawyer Eunice is here. Can you please tell us your question?
Yeah, good afternoon, Eunice. God bless you. Thank you for everything you've been doing.
Thank you.
I just have a question, but it's regarding my husband, not a child. Can I ask the question, please?
Lawyer Eunice, you said this question is about her husband, but not her child. Is she allowed to ask
Okay,
the
that's
question?
fine. Yes,
Yes.
yes, yes, yes.
Please go on, my
Oh,
darling.
thank you. Thank
Mhm.
you. God bless you. He's staying with me here in UK, but we just need to renew the passport now to become our resident. And already we have applied like 4 months now, and they just send us a note, and they send a code to open the note. But anytime they ask about the passport in the working place or the status, we should just show them the form so that they will know that we have applied. That is more than 4 months now.
Okay. So your question is that normal for the application to take that long for 4 months?
Yes, I
Okay.
don't know why it's that long.
Okay.
We are still waiting. We have not received
All
anything
right.
apart from that information that we should show at work.
Okay.
That they
Okay.
should, to keep them informed that the application is with them.
Okay. All right. Lawyer Eunice will answer your question.
Okay, so obviously, I'm guessing you've done a leave to remain application and you are still waiting for them to make a decision. So, usually,
Yeah,
with all leave to
Yes, Lawyer Eunice, go on. Yeah.
okay, so with most leave to remain applications, once you've submitted it and then you've had your biometrics enrolled, from that point onwards, of because they now have your documentation, they can go on to process it. They usually would have done it within a few weeks before COVID, but as of now, usually they would need more time. And so, if you're lucky, you will have a decision within 6 months from the time you had your biometrics taken. Most of the time, I think that most people are going through this, and it's not just you, where you have put in an application and they are basically taking longer than the 6 months, for instance, to make a decision. If that were to be the case, then you can obviously make a complaint to say that it has been more than 6 months since you made your application. You just want to know what's going on because there has been a long delay, for instance, and is causing you unreasonable anxiety and all of that. But in the case where, for instance, it's taking less than 6 months, I would say you would just have to keep waiting for them to make a decision. And some of them who are proactive will send you an email if they require more documents and the rest of it. And so you can make a complaint. There's an online complaint form on the .gov.uk website. If it takes more than 6 months, you can go on and make a complaint, and then hopefully they should get back to you as soon as possible.
Okay.
Thank you.
All right. So please be a little more bit patient. You've got 2 extra months. Then from there you can, get in touch with them to find out the reason for the delay. Yes.
I know it is me. I am a citizen of
Yes. Exactly. Yeah. It's because of the pandemic. So it's a bit slow at the moment. So be rest assured. Keep your fingers crossed. You might probably hear from them. Thank you so much for calling us.
Thank you very much.
Okay. All right. Take care. Bye bye. Yes, Lawyer Eunice. So you were talking about the circumstances. Were you done with the circumstances?
Yes, I was just giving a general overview of scenarios where a parent who, for instance, is working within the armed forces or is working within a government service outside the UK or in an EU institution outside of the UK, or even somebody who used to be in a British overseas territory such as Hong Kong, which we now know is no longer an overseas territory. So, of course, you have all these different scenarios, and then those, of course, who, for instance, have leave to remain and have brought their children to come and live with them in the UK. And you have those, of course, who would have come into the UK with, for instance, indefinite leave to remain, for instance, coming to now live in the UK and will have the entitlement to basically register as British. And so you have all these different scenarios of people who would be working or would be outside of the UK who would then have the right to register as British, even though they were born outside of the UK. And so, of course, there will be people who will be thinking, okay, so even if my child was not born in the UK and I now have settlement or I now have indefinite leave to remain, it's still possible for my child to register as British. And that is also something that um, some viewers may not know and some viewers may be aware of. Yeah.
All right. Okay. Eunice, Tammy saying, dear lawyer, I would like to ask a question, please. I managed to bring my 2 sons to the UK in 2018 when they were 15 and 12 years old. I applied for indefinite leave to remain 2 months ago and would like to find out whether I can add them to the application for naturalization. What documents will I need to include?
Okay, so in this case, you have 2 children. One is 15 and one is now 12 years old. And she's now applied for indefinite leave to remain. And she wants to know if she can add the two to her application. So it's good that she says that she had previously got in leave to remain. And so I'm assuming that the children were also with leave to remain in the UK, and it continued when she renewed her leave to remain as well. So now that, of course, she's applied for indefinite leave for herself and her 2 sons, of course, they will grant them in line with their parents if the parent continues to meet the requirements. So once they've been granted indefinite leave to remain, of course, if she meets the good character requirements as a parent who is applying for British citizenship through naturalization, then of course she will be making the application usually 12 months after she has been granted indefinite leave to remain. So she would have to wait for that 12-month period after she's been granted indefinite leave to remain to apply for naturalization. And then when it comes to the children, because they will still be under the age of 18, they wouldn't come as applicants under her form. They will ask if she has any dependents on the form AN one, from AN, but they would not ask for them to be included as applicants on the application. So she will need to complete a separate application for them. And of course, she will need to complete a form MN1 for them. And when it comes to completing the online application, which is for the children, she will complete a separate one for them, and then it will ask for her to add another applicant who is a child, and then she can include the other child onto the application. I did one very recently for a family, and so with the children, if it's the same form MN1 that you're completing, you can add applicants as and when you go along. And so it's of course, the same form, but then you can add the applicants on. Whereas for the parents, it will be a completely separate form because the form that they have for naturalization is different. So once, of course, her time is up for naturalization, she can complete her form and then complete the children's form separately. And then, of course, they can all be submitted on the same day. And so now that we have documents that are scanned instead of sent by post, most people use the option for scanning and then the documents are uploaded. And before you know it, very soon you would have a decision. So, in terms of the documents that she can add, she will have to include her passport, the children's passport, her indefinite leave to remain biometric card, and then, of course, if the children are also granted indefinite leave to remain, she will include their biometric cards as well. She will also have to include evidence that, of course, they are her children, so the birth certificates for the children will be included there as well. And then she will also have to include any evidence of her residing here in the UK for the past 5 years because she's completing a naturalization application. So she will need evidence for the past 5 years. And when it comes to the children as well, they would also need evidence of their residence here in the UK. And so sometimes when it comes to registering children as British, they are looking to see if the children have either resided here for a period of 3 years or 2 years, depending on which section they would be registering the children under. So usually, if it's under Section 3(1) of the British Nationality Act, they're looking at a residence period of at least 2 years under the Home Office guidance or policy. So it would mean that, of course, if they can show that they've resided here for at least 2 years with the parents, they can then go on to provide the proof of address for that 2 year period. And then, of course, include any school letters, hospital letters, GP letters, whichever it may be, and then send off. So the parent, of course, will have the other documents to show they meet the English language requirement and they meet the life in the UK requirements, and they haven't spent more than 450 days outside of the UK. So all of those requirements will have to be met by them. Also have their proof of residence in the UK included with the documents as well. So yes, when it comes to making the application, it's an online application, and then the documents can be uploaded or scanned and uploaded. And if for any reason they do not have that facility, when you go and have your biometrics taken, they can also scan the documents at the biometric center to be uploaded to the Home Office as well.
Okay. All right. Okay. Um, I've got a question for Maddie saying an application was submitted for my daughter to join me in the UK, and she was granted indefinite leave to enter just last year. She's now 14 years old. When will it be possible to register her as British?
Okay, I do get a lot of these questions because when the child comes and they are granted indefinite leave to remain, it's like, okay, so the next thing is I want to register this child as British, even though she was not born here in the UK. So when is it possible for me to do that? Um, she's also mentioned that the child is now 14, and so of course, if the child came into the UK last year, the Home Office has its own policy in regards to registering children who are born outside of the UK and are now currently living in the UK. And if they were to consider the child's best interest and their years of residence here in the UK, they can also consider things that are compelling factors or circumstances. So, if, for instance, the child is a child who maybe has some medical issues and the whole family is currently, should I say, settled and British, and she might be the only one who is not British, and she's looking to now register as British, then the parents have the option. So I'm assuming because the mom also had settlements, and that's how the child was able to come into the UK with indefinite leave to enter. And in that case, of course, if she's saying that she's registering this child as British, she would need to be able to show that at least this child is still under the age of 18, and this child has at least lived in the UK for a period of 2 years based on the Home Office policy or their guidance. And
Mm.
so, if this child is now 14, they're also going to look at her good character, because from the age of 10 in this country, you are known to be able to commit criminal acts. And so, if the child is 10 years old, they would look at their good character as well to see that they haven't um, committed any offenses, and they are people that they would seem to be of good character. And so, of course, when it comes to children, they will look at these things as well and look at evidence of their 2 year requirement of residence in the UK. And if they have continuously lived here since they came, then of course they can look at the circumstances in which they are in. If their family members, for instance, all have certain British citizenship, it might seem unfair that this child will not be able to register as British. And there are quite a number of factors that they look at in regards to a child who's registering under Section 31, because it's to the discretion of the Secretary of State. So if
Oh,
the child's mother is saying that, well, the child's father, I really do not know his whereabouts. When I made the application, his whereabouts were unknown. He's not here in the UK, and there is no way that I can get his consent. Of course, they will go ahead and grant, because she's already mentioned that she doesn't know the whereabouts of the father, for instance, and therefore it is important that they look at all the circumstances. As long as there isn't any court order to say that the mother cannot do anything for the child unless both parents agree, then she is within her rights to basically make the application for the child to be registered as British, and then they can go ahead and look at the evidence that has been brought forward to then register the child as British. So, in such a case, once the child has lived here for a continuous period of at least 2 years, then she can go ahead and complete a form MN1 for the child to be registered as British.
okay. All right. Someone just asked a quick question. I think it's in relation to the gentleman who asked about applying for naturalization after having indefinite leave to remain with his two children. Someone is asking, when you are given the indefinite leave to remain, how soon can you then progress and apply for naturalization?
Okay, so in terms of an adult, usually if you look at Section 6 of our British Nationality Act, it refers you to Schedule 1 of the British Nationality Act. And so you have different requirements. So the first requirement is the fact that the person is of capacity. So it means that the person is mentally stable to basically make the application. And that person, of course, should be able to show that they're of good character. And of course, that there hasn't been any restriction to their leave for the past 12 months, and that they haven't, from the last 12 months, been absent from the UK for at least um, 90 days. And of course, within the 5 year period before they were making the application, they haven't been absent from the UK for the past 450 days. So, of course, if there isn't any restriction to your leave for the past 12 months, then that means that you have indefinite leave to remain. And we all know that once you have indefinite leave to remain, there aren't any restrictions or limitations to how long you can live in the UK, as long as you're still resident here in the UK. Because most people who have indefinite leave to remain, if you go and live outside of the UK for more than 2 years, you can lose your indefinite leave to remain. So as long as you've been here in the UK and you haven't stayed out of the UK for more than 2 years, and you are able to say that, yes, I've lived here continuously since I was granted indefinite leave to remain, within that 12-month period, I really haven't been absent for more than 90 days, then of course you can make the application for naturalization after a year or after 12 months of obtaining your indefinite leave to remain.
Okay. All right. Right. Um, Another question. Yes. Okay. Yeah, this person wants to remain anonymous. I have 2.5 years leave to remain, and my son's father has indefinite leave to remain. My son's father and I are not together, and we were never married. We came to the UK with our son over 10 years ago and later separated. I'm married to someone else, and my son's father wants to apply for British citizenship for his son, who is now 17 years old. Will he be able to apply for his son?
Okay, so here we have a mother who is no longer with the child's father, but she's looking to see if she can apply for her child before the child turns 18. And I think
Yes.
she is good to be concerned about the fact that her child is going to turn 18 soon and wants to apply for British citizenship. The other has indefinite leave to remain and wants to do that for the son. Um, of course, if the child was born at the time the father had British citizenship, I'm not sure if he was born at the time the father had British citizenship. But if
Oh,
it was the case that, for instance, the father had settlement or the father had British citizenship before the child was born, then of course we'll be looking to see how the child can be registered under Section 2. But if it's the case that maybe the father became settled or he became British after the child was born and then they went to bring this child, when you look closely at our British Nationality Act, there have been quite a lot of changes, and one of them being the fact that those who were not married before the 1st of July 2006 could only, should I say, have the right to British citizenship given to them if the mother, for instance, was settled or British. So if the parents were not married, the father could not go on and transfer his citizenship to the child. They would only pass it on. And so it meant that a lot of children were in limbo if the parents that we had the British Citizenship Proof of Paternity Act regulations in 2006. And so that made it possible for parents who were not married and children who were born from the 1st of July 2006 to then have British citizenship passed on through their father. And so, of course, if your child was born before 2006, and I think this child is 17, so I'm definitely sure that this child was born before 2006. So in this case, where the parents were not married, it is going to be a hard one because if the father was not married to the mother, then they cannot pass on their British citizenship to this child. But if the mother wants, we have the discretion of the Home Secretary under Section 3(1). And if the child is still a minor at the time that they are making the application and they are of good character and they have lived there for at least 2 years, then it is within the discretion of the Home Secretary to grant this child British citizenship. So although the father may not have been married to the mother before July 2006, the Home Secretary is within her discretion to look at the circumstances of this child because they still have a duty to look at the child's best interest and they can still this child British citizenship even though the father may not have met the requirements at the time. And so, yes, she can still give it a try and make the application, including the documentation that shows that the father is settled or has naturalized here in the UK. And of course, it is their child, so the birth certificate, her passport, her status here in the UK. If the father naturalized, like I said, she would include that with the application and then proof of the residence of the child. And of course, once they've submitted all of these documents, the Home Office will be in their own discretion to either grant this child British citizenship or not. And so, of course, she can still take the plunge because the child is going to turn 18 soon. So she wants to make sure that she puts in the application before.
Okay. All right. Adiola is asking this question as well. Um, yes, it says I was born in Nigeria and I got a British citizenship through my parents. I
Mm,
was told my daughter born outside the UK can't have a British passport. How can I
mm,
bring my wife and my daughter from Nigeria? She's almost 2 years old. And he's
okay,
also saying we married before our child is born and had my
okay,
British passport for the last 17 years.
okay. So he's a typical person who had his British by descent. So
Yeah.
he was born in Britain or in the UK. His father probably or his mother probably became British. And then
Yes.
because he was born outside of the UK, his parents were able to pass on British citizenship to him under
Yes.
Section 2(1). So his parents passed it on and he has British citizenship by descent. And so in the case where he also has now had a child outside of the UK, unfortunately, the British Nationality Act does not allow for a second generation of somebody born outside of the UK to obtain British citizenship. So if he wants to bring his child, of course, he now has British citizenship, so he can apply for leave to remain for his wife and his child to come and join him in the UK because he's a British citizen. So once he comes to the UK and he is able to show that he is in the UK, he wants to apply for leave to remain for his wife and his child under Appendix FM because he's a British national, he has a spouse, he has a child. He can bring them into the UK so that they have leave to remain. Within 5 years, they should be able to have indefinite leave to remain. And he can, of course, later on register the once they meet the requirements. So once they've been granted indefinite leave to remain, I'm sure very well that the child will be able to register as British under the discretion of the Home Secretary under Section 3.1. So, yes, that is his route through which his child can become British.
Okay.
Yeah.
So if you, your parents, like his situation, it was
Mm-hmm.
straightforward. His parents
Yeah.
being British citizens
Yes.
to pass it on to him.
Yes.
But
Yes.
when it's just him trying to
So
get British citizenship for the son and daughter, it's a different,
so when it's like a
criteria.
second
You have to
generation being born
exactly
outside the UK. So,
outside
for
the-
instance, if I was born outside of the UK, my parents were British, and they passed on their British citizenship to me, and then I also went to live, let's say, in Cambodia, and I had my child, I will not be able to pass my British citizenship on to my child because, first of all, I was born outside the UK, and the British Nationality Act under Section 2.1 allows my parent to pass on their British citizenship by descent to me,
Okay.
who was born outside of the UK. But I continue to live in Cambodia with my husband, and I now have a child. Unfortunately, the British Nationality Act doesn't allow for that second generation of my family to have British citizenship through me. And so, unfortunately, unless I come and live in the United Kingdom with my family, they would not be able to apply for British citizenship.
Okay. All right. Brilliant. Brilliant. Adiola, so that is it. Lawyer Eunice has been able to answer your questions. I think I'm done with all the questions for today. I would like to say a very big thank you to all those who joined in watching us. And we really appreciate, you taking time off and making this program very interesting for us. And also those who sent in their questions. We very much appreciate you. Lawyer Eunice, could you please round up on what we so far discussed, just briefly, and also give us your contact details if anyone wants to get in touch with you, to for help, if I should say. Yeah.
Yes. Okay, so yes, we've been discussing very briefly about those who would like to register their children who were born outside of the UK. So I know a lot of people would know how to do so if their child was born in the UK. But if your child was born outside of the UK, and for instance, you had leave to remain when you brought your into remain and you want to register this child as British, we obviously looked at Section 3.1 of our British Nationality Act. Of course, if you are able to show that this child has resided here for at least a period of 2 years and this child is of good character and is under the age of 18, of course, you can go on and make the application with the relevant documents for this child to be registered as British. If, of course, you were somebody who had British citizenship or settlement before the child was born outside the UK, so let's say you had naturalized as a British citizen, you went to live outside the UK, you had a family outside of the UK, and you now want to register the children, you can do so, or you can apply directly for a passport because the children will be seen to be automatically British under Section 2(1) of our British Nationality Act. And I also explained that before 1st of July 2006, if the parents were not married, and of course you wanted to register the children as British because maybe they are saying they are getting their British citizenship through the father, of course you would have to register these children to obviously have them receive British citizenship from their father. And so that is a discretion under Section 3(1). And most people would use the form UK F to register their children if they were gaining British citizenship through the father. And so, of course, if you are a mother and you were not married to the child and the child was born before 1st of July 2006, they'll be looking to register them. But if the child was born after the 1st of July 2006, they can go ahead and apply for a British passport straight away. And we looked at examples where, for instance, I've had my child outside of the UK and I was able to obtain British citizenship through my parents. And so if I gave birth to my child outside of the UK, I cannot transfer my British citizenship to my child because I myself was born outside of the UK. And so the British Nationality Act does not allow for that second generation to be able to apply for British citizenship for that child. So, yes, there are so many other categories where, for instance, a person who was born in a British overseas territory, such as Hong Kong, would be able to register as British, or if they were part of the armed forces, or if they were working within a government service or within an EU institution which was outside of the UK. These
Yeah.
different categories of people can also register as British. But of course, as we all know, we at BWF solicitors do not only do immigration law, but we do deal with other areas of law, such as family, applying for non molestation and occupation orders, child arrangement orders, different parts of civil litigation, housing, and social issues. And so, if you do need our legal assistance in any matter regarding those areas, for instance, uh, do give us a call on 0208 493 7340. And if you would want to come into our offices, our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road, London, and the postcode is N154NP. So it's 4N4. Sorry, let me come again. N154NP. So that is our address as well.
Yes. No, Eunice, thank you. I think the last person who asked the question, Mr. Adiola, is saying he would like you to process his application for him. So
Okay.
I asked him to take your details in case he's missed something regarding contacting you. I'm very happy to forward your details to him. So I think he will be
Okay.
contacting you by Monday to book an appointment for a consultation. So yeah,
Okay.
that is it.
Thank you.
All right.
Yeah, let me
Okay.
put my
Yes.
mobile number out as
Yes,
well.
please. Yeah.
So the mobile number is 075 3910. So 075 3910.
Thank you so much, Laura Eunice. Yes, so look at how time flies so quickly. All too soon, our
I
time is up.
know.
Yes, our time is up, and be rest assured we'll come your way same time next week with another interesting topic. Um, I would like to take this opportunity to say a big thank you, first of all, to Lawyer Eunice and her team at BWF Solicitors. Thank you so much for coming our way every Saturday to educate us. Very much appreciated. I also like to say thank you to our sponsors, Victon Estates Limited and Eagle Heights International School, your number one maths and English tuition center. Their contact number is 077 322 077-322-02319. So yes. Sorry. Until then, we'll come your way next week, same time, 12 noon. Take good care of yourself and see you next week, same time. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.